With permission, Mr Speaker, I should like to make a statement. As the House will recall, in his statement on the 4th of February 2008, my right honourable friend, the Justice Secretary, announced that he and I had jointly agreed to ask the Chief Surveillance Commissioner, Sir Christopher Rose, to conduct an inquiry to investigate the circumstances relating to the visits to Baba Ahmed at Her Majesty's Prison Wood Hill by Sadiq Khan MP in May 2005 and June 2006, to establish whether the visits were subject to any form of surveillance, and if so, by whose authority and with whose knowledge, and to report his findings to the Prime Minister, the Home Secretary and the Justice Secretary. Mr Speaker, Sir Christopher has now completed his inquiry and submitted his report. I should like to thank Sir Christopher for his work and the speed and efficiency with which he carried it out. I am today laying his report before the House. Copies are available in the Vote Office. Mr Speaker, there should be absolutely no doubt about the vital importance of covert surveillance techniques and the contribution that they make to the protection of all of us from terrorism and other serious crime. Covert surveillance is an essential tool for the police and security and intelligence agencies, and the ability to make use of it must be preserved. It is, however, right that its use is carefully regulated. The Regulation of Investigatory Powers Act 2000 mandates the form of authorisation and inspection for a range of investigatory powers. These include two distinct types of surveillance: intrusive surveillance and directed surveillance. Intrusive surveillance is defined as the covert acquisition of information on a residential premise or in a private vehicle. It requires the authorisation of a Secretary of State or of a Chief Constable or equivalent, together with the approval of a Surveillance Commissioner. Directed surveillance is any other covert surveillance that does not constitute intrusive surveillance. Directed surveillance can be approved by senior officers in the police, but does not require, under any circumstances, authorisation by a Secretary of State. The House will be aware that the Act also covers the interception of communications. This is a power that can only ever be used for limited purposes and requires, in each case, the explicit prior authorisation of a Secretary of State. It is to interception and to other surveillance requiring the approval of a Secretary of State that the Wilson Doctrine applies. Sir Christopher makes clear that, and I quote, "The surveillance which I am investigating does not appear to me to be within the Wilson Doctrine, because it does not give rise to interception as defined by the legislation, nor would it require authorisation by the Secretary of State." This is in line with the government's stated position on the doctrine. As the facts set out in Sir Christopher's report make clear,